Stephen is an attorney. He's traveled down from Athens, Georgia this morning to speak to us. And he is a Madison Forum member, and we're very, very proud of that and all the work that he does. But Stephen's going to be speaking on the pioneering the use of civil RICO actions to combat Georgia's expansion of sovereign immunity to prevent government accountability and protect criminal conduct by state officials. Hopefully all of you saw that and saw the accompanying attachment.
I am really glad to be here speaking to this group, the Madison Forum, this morning. I was thinking about my talk yesterday, and just by coincidence I was sitting in a little restaurant and they were playing the news, and they were talking about the scandal with the treatment of the young gymnasts in the Olympic program that had gone on for years and years and years and years. And everybody knew about it, but the girls tried to tell people about it, and nobody listened to them. And they made a remark on this. One of the commentators made a remark about the culture of indifference that had surrounded that, and had gone on forever. People knowing about it, and now all of a sudden it's a huge scandal, and something must be done about it. But people knew this was going on for years. One of my favorite movies that I relate to, Academy Award-winning movie, Spotlight. Huge scandal going on in the Boston community, powerful establishment, with major crimes being committed. Everybody sort of knew it was going on under the radar, and it went on for years and years and years and years with nobody doing anything about it. Until all of a sudden it's a huge story and it's a giant scandal, and all of a sudden, all the cards, fall all of a sudden. After, I relate to the lawyer in the movie, Mitch Garabedian, who is, fighting these lawsuits against the criminal activity in the church, and in the movie they dismiss it. Have you heard of Mitch Garabedian? Oh yeah, he's kind of a crank. He's been, pursuing these suits for 10 years, but he's a crackpot. And then it turns out, that he was, completely right all along, and everybody agrees with him after 10 years. But I know there's a wide range of views, to say the least, in the Madison Forum. But one thing there is not in this group, I believe, is a culture of indifference, that everybody really wants government to be accountable, and for public officials to do their job on behalf of the public, and do it in a correct and honest and accountable fashion. And I think that everybody agrees on that. And as divided as our country is today, I think that's the one thing that could unite the country from the left to the right, that people believe that the government should be accountable and the government should be honest. And when I just start telling my tales, which are kind of horror stories from my real cases, that's one thing I've noticed, that people, no matter what their political persuasion, they find it horrifying. And I think it's I would love to see Georgia get united behind cleaning up our government a little bit. Just to start with, we've had people throwing out questions today, so I'm going to throw out an abstract question. How many of you believe that elected public officials, state government officials in Georgia today, should be immune and unaccountable for using their office to commit crimes, to commit felonies? How many people believe they should be immune for that? I don't see any hands. How many people,
a lot of support.
How many people believe that a public official who uses or abuses his or her office to commit a crime, to commit a felony, in particular a series, ongoing pattern of related crimes, should be held accountable for their actions? So everybody seems to agree on that, and yet you would be surprised at what is going on in Georgia today, and what is being degree to which government officials are not being held accountable under this doctrine called sovereign immunity. And it's no coincidence that this is happening in Georgia. Every state has some version of sovereign immunity. Georgia right now has the most expanded application of sovereign immunity of any state in the country, and it is growing all the time because of acts by the Attorney General, by the state Supreme Court, and it goes on and on. But you know, the state of Georgia is named after King George, and they're taking us back to a time of King George, where the king could do no wrong, and where the government cannot be held accountable, and state officials cannot be held accountable for their actions, even though they be criminal. And I'll just give you some concrete hypotheticals based on the real cases to give you a better understanding of what I'm talking about. In this hypothetical, imagine you're a college president in Georgia in the university system, which is a giant statewide system with billions and billions of dollars and tens of thousands of employees, and you take over a college that's having a huge budget crisis. When you take it over, you resolve the crisis, you double the enrollment, you double the revenues of the school, you solve the deficit problem at the school, you set aside a $20 million reserve, and the school is winning national awards. You, as president, you're winning national awards of like the best college president in the country. And then, unbeknownst to you, there are state employed budget officials, finance, vice presidents of finance in your college who are diverting funds. Where those funds are diverted to, we'll get to at the end, but they're diverting funds. They're drawing multi-million-dollar chunks out of that school's reserve without informing you as the president. And in fact, they are giving you, in the financial reports from these state college budget officials to the president of the college, they're informing you that we still have this huge reserve and a very large budget surplus, when in fact they are deficit spending, drawing money out of the reserves till the reserves are almost gone. So you're the college president, you think you have a reserve and a surplus. That's being reported to you that these officials underneath you are actually drawing the money out of the reserves, and I'll argue later to elicit illegal criminal purpose. But while the school is actually going into the red, the reports to you are, it's all in the black. And take the hypothetical a step further, the state college finance officials who are falsely reporting budget surpluses to the president actually go around and above him and are reporting to officials in the university system of Georgia that there is actually a $16 million deficit. And the university system of Georgia officials, in the hypothetical for illustrative purposes, will say one of them was the former chancellor of the university system. For illustrative purposes, we'll say his name, but for the hypothetical, his name is Hank Huckabee. And another one of the university system of Georgia officials say now is like the current chancellor of the university system, Steve Wrigley. And they have received this report of a $16 million deficit that has bypassed you as the president. And instead of coming back and informing you, they spend several months scrambling and scurrying, and it shows this in all their documents and internal communication, scrambling and scurrying to avoid any blame, evade any blame for themselves for this budget crisis developing. And the documents clearly show they're trying to figure out how to blame it on you as the president. And so they all of a sudden come up with a grandiose announcement that there's a $16 million deficit. They blame it on you as the president. They report that to the Atlanta Journal-Constitution. They have already decided to fire you, and they have already named your replacement, but they're trying to get you to resign so that they can avoid all of the Board of Regents policies that would come into effect if they fired you. Because if they fired you, they would have to give you a statement of charges of why they fired you, and they would have to give you a hearing, a due process hearing, and allow you a chance to defend yourself. But they actually pretend that you've resigned, and so that they can avoid all of that. And so you as a president, after you've been fired, you didn't know you were fired, but you were fired, you were denied your hearing, you were blamed for $16 billion that was diverted, and now 5 years later, $9 million of that money has still never been accounted for. But you go to court, and the Attorney General argues, and the court tells you that you can't do anything about what happened to you because these state officials beneath you who falsified the reports, the financial reports, which is a felony. It's a felony to knowingly falsify the reports of a state agency. The University System of Georgia, people above you who misrepresented the financials to you and to everybody else, misrepresented their knowledge, because when the scandal broke, they falsely claimed we didn't know anything about the $16 million shortfall. We knew nothing about it until today, when in fact the documents showed that they had known about it for months and were scrambling to try to do CYA control and to blame it on you as the president of the college. So there you are, and that's been done to you, and you go to court, and the Attorney General argues, first of all, that it's your fault that that this financial shortfall developed without your knowledge, because you, as the college president, you should have gone and looked at the ledgers and work papers of the accountants to determine that your vice president of financial operations was lying to you when he was claiming there was a budget surplus when actually there was a $16 million deficit. So first of all, that's your fault, according to the Attorney General. And then the Attorney General argues, and the court agrees, that you, as the hypothetical president, will hypothetically say your name is Anthony DeColey, and this is like a TV movie, any resemblance to any person. You, Anthony, pretend you're Anthony DeColey, you cannot sue because these state officials who have falsified financial reports, which is a felony, who have misrepresented the financial reports to you and to the Atlanta Journal-Constitution, everybody, which is also a felony, that those state officials who knowingly falsified state agency reports to conceal the theft of $9 million in public money are immune from your suit. And just imagine yourself in that place and how you would feel about that. And that's a hypothetical that comes from, loosely based on one of my cases. Take another hypothetical. Say you are the Attorney General of Georgia, and this scandal has just happened at this hypothetical college called Georgia Perimeter College. And there's supposed to be a hearing, which is required by law, required by Regents policy, required by constitutional due process, because the president has been blamed for this missing money and fired for it. There's a hearing that's required. You, as Attorney General, you block that hearing. And we'll say, hypothetically, your name is former Attorney General Sam Owens. And you block that hearing. There's supposed to be a criminal investigation because there's, as far as anybody knows at the time, there's $16 million missing, never been accounted for. You as the Attorney General, so there are all these allegations of criminal fraud going on in the university system of Georgia. You as Attorney General, as the documents show, you actually block any criminal investigation from occurring into the wrongdoing in the university system. And then the university system says, thank you, hypothetical Attorney General, we're going to appoint you to a $450,000 a year job. Thank you very much. And some hypothetical nut attorney will say, named Stephen Humphreys, tries to sue on behalf of Kennesaw State, hypothetical university called Kennesaw State University, to block that appointment and say, you cannot take an Attorney General who is the university system of Georgia, cannot take an Attorney General who has just blocked a criminal investigation of $9 million missing and say, thank you, Mr. Attorney General, we're going to give you a $450,000 a year job. Go enjoy it. And that suit is blocked because of why? Can't bring an injunction to block that illegal appointment. That also violated every Board of Regents policy in terms of the kind of searches they should have and everything else. But you cannot bring that suit because the state, like King George himself, has sovereign immunity. What does sovereign immunity mean? It means, of course, it comes from the days of the divine right kings. It comes from the days before the American Constitution. It says we don't have any royalty. Our Constitution says that. We have no royal titles in this country. We have no divine right sovereigns. And it comes from the doctrine that the king can do no wrong. What it means specifically in court, when I bring a suit on behalf of Anthony Ducoli to say these people knowingly falsified the financial reports of a state agency, which is a felony, in order to conceal the theft of $9 million, and they blamed it on Anthony Ducoli and fired him and destroyed his life and career while they all went their merry way, that those people who did that have sovereign immunity. So the Attorney General files what's called a motion to dismiss, which means your case is thrown out. And just to be clear, it means that it's not that your case is ever heard. It is the door to the courthouse is shut to you. So in these cases, and this is what is the pot that's boiling, and it's boiling right now, and it's boiling with Sam Owens leaving Kennesaw State University again, it's boiling with some other things that are going on. These hypotheticals I'm telling you about are completely documented in the state's own records. So what they're saying when they say we have sovereign immunity, that means even if the state officials did commit the crimes, and even if you have evidence from the state's own records that can prove they committed the crime, and you can walk into the courtroom and present it to a jury and say, look at this evidence of this crime that was committed. It's right here in the state's own records. And try to get the jury to believe that and to enter a judgment against that state official for abusing his or her public office in order to lie and steal money from the public, that you don't get to present that evidence. So they're saying, even if we committed the crime, And even if you can prove it, you do not get to walk in the courthouse door to present your evidence. The public will never see it, jury will never see it, and these people can never be held accountable. The function of a court in a trial is to be able to present the evidence you have and try to convince a jury or convince the public that these people committed the wrongs that you allege. And when they impose sovereign immunity, it means they don't care how much evidence you have, you do not get to walk into the courthouse door. So I filed these lawsuits starting 5 years ago and still fighting. And they make it sound like, well, you're losing, you don't have any evidence, and Sam Owens, went around telling people. My favorite thing he said about me was that I was an outlandish conspiracy theorist. and obviously a kook and everything else. And I always say, forget, it's not about me. Look at the documents. The documents show what happened. But according to Sam Owens, according to the courts of Georgia, I do not get to walk into the courtroom and show that evidence.
Created a class of people.
This scandal has infected the entire state government to the degree it's actually infected the judiciary. So we talked about the Board of Regents, the university system, their role in all this. The Attorney General, and let me make another point about sovereign immunity that people don't understand. Sovereign immunity protects state officials against a civil lawsuit. All of these things I'm talking about are state and federal crimes, violate state and federal criminal statutes. So in all these cases for knowingly falsifying the financial report of a state college, stealing $9 million, all of that stuff, they could be criminally prosecuted. But who is the person who would bring the criminal prosecution? The Attorney General of Georgia, who is not only did not investigate the $9 million. There's $9 million unaccounted for 5 years later. And do you believe that nobody is looking for it? If I lost $9 million, I'd go looking for it. But 5 years later, $9 million, nobody is looking for it. And the Attorney General actually, and we can prove that the Attorney General actually blocked any investigation, blocked any hearing, blocked any criminal investigation by his office or independent criminal investigation. And there has been no accountability whatsoever 5 years later. The cases in, I'll give you another hypothetical of the third case. So the Attorney General, who should be investigating and should be prosecuting, is actually defending against the civil cases, both as the attorney for himself and his co-defendants, but also as a defendant, which is unethical, but that's another sidetrack. So you have the Attorney General defending these cases. In the original case that started 5 years ago, I'm trying to bring the case against the university system. It's being defended by Attorney General Sam Owens. And we find that Owens has actually done things to obstruct the investigations and so on. So we try to bring claims against Sam Owens and against the Attorney General's office. The judge in the case blocks us. In Georgia, you're supposed to be able to amend your complaint, supposed to be able to add parties to all this stuff very easily. The judge says, no, you cannot add Sam Owens as defendant. She keeps making all of these rulings that protect Sam Owens. And so we eventually do some research after these rulings become really extreme. And they're very basic violations of statutes for which it's not as though the judge had some room for interpretation. For example, Georgia law is very clear that you, up until the time of trial, you have the right to amend your complaint to add claims. You don't have to have the judge's permission. The judge has no discretion to block you. We try to amend our complaint, and the judge purportedly bars it. It says you are denied. You may not amend your complaint to add these claims against Sam Owens. It's something the judge had no discretion whatsoever to do, but the judge is doing. We started to think this is very peculiar. We look into it, find out that the judge has personal, very close personal, financial, and political connections to Sam Owens. And so we file a motion to recuse the judge, that you cannot be, presiding over this case. The judge denies that motion, claiming that and this sounds nutty, and it is nutty, but this is true. When you file a motion to recuse a judge, you have to file an affidavit with it, kind of attesting that this evidence I'm presenting is true. I file it as the attorney. I file the motion to recuse. I file with it the affidavit that verifies the truth of the motion. The judge denies the motion to recuse on the grounds that we did not file the supporting affidavit. This is what is truly nuts. You can go look in the public record and see that the affidavit was filed, and yet we're denied on this blatantly, patently false grounds. And this is where I started to get, very disturbed when, so we brought a mandamus action against the judge, and to say, the judge has to follow the law. The judge cannot claim that we did not file an affidavit when we did file it. The judge cannot say you cannot amend your complaint. I'm barring you from amending your complaint when the law says we can amend our complaint whenever we want to. We don't need the judge's permission to do it. So we file what's called a mandamus action to get another court to come in and order this judge just to follow the law. And these are things that, where the judge has no discretion, she has no room for interpretation. It's a very clear law and she has to follow it. She goes and answers that other court and denies the whole long string of things that she did. She denies that she denied the motion to recuse, saying we didn't file the affidavit. She denies that she barred us from amending our complaint. And so, and as has become a pattern now, the judge brings claims against me, saying that I should pay her damages, and she brings it using there is a statute that allows a judge to bring a lawsuit against somebody who brings a frivolous claim against the judge. That same statute says that the judge cannot bring those claims in the case of a mandamus action, which of course is what I filed. So the judge brings claims against me under a statute that says she cannot do that. And so it's just becoming more and more lawless. That's what the only word I have to describe it. She goes to the other court and denies all of that. She denies that she brought claims against me under a statute that forbid her to do that just for the purpose of intimidating me. So we actually bring claims against the judge for committing the crime of going in front of another judge and lying about her conduct. And so that brings us to another immunity, which is, so we bring those claims and the judge says, ha, I have judicial immunity. So probably none of you knew. I'm surprised at the number of people. Let me ask you, how many of y'all knew that in Georgia, sovereign immunity protected a state official from committing crimes?
No,
Only race.
from being charged.
I mean, that's surprising. Usually, I'll ask a group, how many of you knew the state official has immunity for committing crimes? And people would say, what? I have no idea. How many of you knew that a judge has judicial immunity for any conduct, in the case of this judge, in her courtroom, in a case she's presiding over, even if her actions are corrupt, criminal, even if she's taking bribes, how many of you knew that a judge has judicial immunity for, say you go to court, the judge rules against you because she took a bribe to rule against you. How many of you knew you cannot sue the judge because she has judicial immunity? Who knew that? It's a surprising concept. So my business is trying to work through all these walls and smoke and mirrors. So I say, well, that's wonderful that the judge has immunity for anything she does, even though it's criminal, in her courtroom in a case she's presiding over. But this judge went out of her courtroom, went over to another courtroom, went in front of another judge in a case she was not presiding over, and committed a string of felonies lying to the other judge. Of course, the judge who decided that case said that hypothetically, Judge Susan Edline had judicial immunity for everything she did in her own courtroom, and therefore all claims against her are dropped. Of course, here's where you have the disconnect with reality. I'm saying I understand that principle. She has judicial immunity for what she did in her own courtroom. She went off into another courtroom in case she was not presiding over, and the judgment is silent on that. So that issue is now in front of the 11th Circuit Court of Appeals. Could be decided any day whether this judge, who we allege entered into a criminal conspiracy with the Attorney General of Georgia to block these claims against the Attorney General's office and against the university system of Georgia, entered all kinds of phony rulings blocking claims against the state, and then went off in front of another judge and blatantly, patently lied about it. Does that judge have judicial immunity? So that's kind of the setup of my three cases. And I told you what I did to try to chip away at that doctrine of judicial immunity. Let me tell you how briefly how I'm attacking this problem of sovereign immunity, and then if y'all have questions or comments, I'd love to hear what y'all think about it. So the way all this got started was I never intended to be a RICO attorney. I was an intellectual property attorney doing copyright cases and stuff. I went to law school at the University of Georgia, so I represented lots of professors because I write books and make films and all this kind of thing that lends itself to intellectual property law. But I ended up representing this professor. This is the very first case, because of those connections, that some of y'all might have heard of. Michael Adams used to be president of the University of Georgia, did not like any kind of dissent. And there was a professor who was a very vocal critic of Mike Adams, and so Mike Adams was trying to get rid of him. You can't just fire a professor because you don't like them or because they speak out against you, because professors have tenure. You have to revoke their tenure, which is a very serious thing, almost never happens. You have to violate very specific Board of Regents policies, like you have to have committed a felony or something really serious to have your tenure revoked. It's so serious that it's actually prosecuted by the Attorney General's office. So I'm representing this professor in a tenure revocation proceeding against the Attorney General, all the machinery of the state. We actually, I won't try to tell the whole story, but to cut to the chase of it, to my great surprise, because I thought, the whole thing would just be rubber stamped and they'd revoke his tenure no matter what evidence we presented. We had a evidentiary hearing, witnesses under oath and everything. Actually proved in the hearing, and the professor, to my great surprise, ended up keeping his job. They did not dare revoke his tenure after it was over, because we not only proved that the charges that they brought against the professor were false, but we proved that Michael Adams and the Attorney General of Georgia knew the charges were false before they brought them. They had actually hidden university records showing that the charges were false. And that's where my antennas started to go up, when I started to go like, is it the job of the Attorney General of Georgia to hide evidence in a case? And that's what we caught them red-handed with their pants down trying to hide evidence. In place of the evidence they tried to hide, and I'm talking about university records that proved that their charges were false and that they knew they were false before they tried to revoke his professorship. They thought, well, the real evidence is no good, we have to hide that, so let's manufacture some fake evidence. And I'm an innocent copyright lawyer. You know, some of y'all may be more worldly than I am. I found it shocking and horrifying when we discovered that and proved that. And it's really like a bad comedy almost. They tried to manufacture fake evidence. Get this. They pretended, and I'm talking about state officials, deans of the college, dean of arts and sciences, pretending to be University of Georgia students, sending out fake correspondence with the names and social security numbers of real University of Georgia students, logging on to a computer database in the name of a University of Georgia student, using their social security numbers, everything, in order to create a fake paper trail of evidence to replace the real evidence that they're hiding. And the Attorney General puts a witness on the stand under oath to testify to the authenticity of this fake evidence that they have manufactured. And not only is it fake evidence they manufactured, and when I started this, I was like, I don't even know under what legal theory you attack this. What is this? What is it? But I eventually realized that what they were doing when they were impersonating these University of Georgia students, they were committing identity fraud. They were committing mail fraud. They were committing wire fraud. They were committing computer fraud. They were engaging in evidence tampering. They were engaging in improper influencing of witnesses. They were engaging in false use of Social Security identifying documents. They were engaging in perjury and subordination of perjury. And these are all, you know, most civil lawsuits are not about crimes. You have a car wreck, you're not saying the person necessarily committed a crime, but you know, whatever. It's they were negligent, that they weren't paying attention. I realized that all of these acts, and imagine you're one of this dean at the University of Georgia, and you go like, I have a brilliant idea. I'm going to log on pretending to be a University of Georgia student. We have a memo from the University of Georgia Office of Legal Affairs actually approving this idea to send out all this fake correspondence in the names of this is, now you see why they're saying, we have sovereign immunity and we are not going to let you in the courthouse door with this evidence. We do not want a jury to ever see it. We don't ever want the public to ever hear about it. So that is, that's what they did. So sovereign immunity in Georgia had been going, I'd say, awry before I ever showed up on the scene. The decisions were being made under what's called the Georgia Tort Claims Act. And tort, if you understand, that's what I'm talking, that's a claim for negligence. Like, we were in a car wreck, you know, somebody driving a state vehicle was negligent and they hit me, and so therefore we have a, you know, claim against the state. You would sue the state for negligence claims under the Georgia Tort Claims Act. And the courts have been making, and we sent out, if you look at the attachment to the, one of the emails, a list of some of the prior sovereign immunity cases that have been brought under the Georgia Tort Claims Act. And they found, you know, wonderful things like a college dean is immune for the rape of a college student. A state trooper is immune for in a traffic, stopping a female motorist and sexually molesting the female motorist during a traffic stop. They said he's immune because he is performing his state functions. This takes you back to what they said in our first hypothetical Georgia Perimeter College. The state official who knowingly falsified the financial records of a state college in order to hide the theft of money, the court said, was immune because he was performing his state financial oversight activities. Of course, I would argue, and this goes, I think it really goes to this culture of indifference and how you even frame these issues. I would go respectfully suggest to the court that knowingly falsifying a state agency financial report to conceal the theft of money is not performing your financial oversight activities. I would say that the state trooper who pulled over a female motorist and stuck his hand up her skirt, and I won't describe the whole case, but sexually molested the female motorist, was not performing his state duties as a state trooper, which is why the court held him. The court said he was a state trooper, he was on duty, he was in his uniform, and he was performing a traffic stop, and those are all parts of his state official functions, and therefore he is immune, cannot be sued for sexually molesting this woman. There's a whole series of sexual molestation, sexual assault, and sexual harassment cases I don't have time to go into, which were the beginning of the expansion of sovereign immunity. So we can say, you know, me too in the state government of Georgia, because the state government of Georgia has been protecting itself from sexual assault and sexual harassment claims under the guise of sovereign immunity for a long time now. One of the worst cases, to tell you briefly, is a state office. Male state office supervisor, female subordinate. Male state office supervisor sexually harasses the female subordinate for over a year. She finally reports him, at which point he makes the case more interesting. After she reports him for sexual harassment for over a year, he threatens to kill her dog and stuff it in her mailbox. And she brings this suit, and that goes in front of the Georgia Supreme Court, and they say he is immune because he's a state office supervisor. And they go the extra step to say it doesn't matter that it wasn't just a case of negligence. It doesn't matter that he acted with malice and actual intent to harm her, which is, you understand the difference between I accidentally ran into you in my car and I decided on purpose to run you over with my car. Georgia Supreme Court said he's immune because he's a state office supervisor. That is kind of how bad it had gotten. So I come along and bother them in a very pesky way and say, well, under the Georgia Tort Claims Act, they've been holding the state officers immune for rape, sexual molestation, murder. Did you know you could be murdered, intentionally murdered in a state prison? The guard who murdered you would have sovereign immunity under the assault exception, assault and battery exception under the Georgia Tort Claims Act. So I come along and say, forget about all this. You know, these are not really cases of negligence, and they don't really belong under the Georgia Tort Claims Act. These really fall under, I'm just a copyright lawyer, but I'm stupid, and I see that these actually fall under the RICO statute. And the RICO statute addresses criminal acts. And the RICO statute is set up to allow either a criminal prosecution by the Attorney General. If the Attorney General someday decided to prosecute himself for crimes, he could do that. Or it authorizes a civil action to be brought by a private attorney like myself against these state officials who framed you, who lied to you about the budget at the college and got you fired while they stole the money. So the RICO statute, it stands for Racketeering Influenced Corrupt Organization. The statute was developed in the 1970s, and it was intended to address the mafia. Because, you know, the mafia is an organization that's committing a related pattern of crimes all the time. And so the idea was, you know, instead of independently trying to prosecute every burglary, every robbery, every extortion, everything by them, you lump all of that together and say this is an ongoing criminal enterprise committing a pattern of related crimes, and you get all of those crimes under one suit. So I said, well, that's exactly what we've got here. at the University of Georgia, we have mail fraud, wire fraud, computer fraud, identity fraud, evidence tampering, perjury, subordination of perjury. These are criminal predicate acts, and they belong under the RICO statute, which specifically authorizes a civil action against people, any association of individuals who has committed such a pattern of criminal acts that harmed you. It says in the RICO statute too, part of the reason we're doing this is because these actions also harm, we as a legislature deem that these kind of acts harm the state of Georgia as well. And the RICO Act says that a governmental entity can be a RICO enterprise. So it authorizes a suit against the state and against state officials. So in all of my cases, so I say, okay, forget the Georgia Tort Claims Act, I'm suing you under the RICO statute, and here's what's happened. The courts have actually expanded the doctrine of sovereign immunity beyond, as bad as it is, the way it's written in the books, to say that it actually covers criminal acts. And that was the first proposition that nobody agreed with, that state officials should be immune for committing criminal acts. But they're saying that even though there is a statute, the RICO statute, that very specifically says a state official may be sued under the RICO statute, and the governor of Georgia, the attorney general of Georgia, and so far the courts of Georgia have said, that statute, we know what it says, but forget about what it says. It doesn't really mean what it says. It's an absurd idea. And there's a Georgia Court of Appeals judge who actually wrote, what an absurd idea. And that judge said, I had a very imaginative theory that the state can be sued and held accountable under the RICO statute. That's what he said. Of course, he dismissed me and said I was, had an overactive imagination. What that judge did not do was read the language of the RICO statute, and you will not find it anywhere in the opinion where the RICO statute very specifically says that the state can be sued. And that's actually, under the Constitution, the law of sovereign immunity in Georgia is that the state has sovereign immunity, which I say is an outdated notion to begin with, but just given that the state has sovereign immunity, but that sovereign immunity may be waived by a statute that says so. And so I come along and say, here's the RICO statute, and it says so. It says the state can be sued. It says a state official can be sued. It says the action of a state agency may be rescinded. And the courts have said, forget what the statute says. We know that the state cannot be sued. So the cases have actually taken an extra dimension, and I'll stop with this thought. So in all my pleadings and arguments in front of the Supreme Court and this court and the 11th Circuit Court of Appeals and everywhere, what I'm arguing now is what the courts of Georgia are doing in order to expand sovereign immunity to cover everything. State official can murder you, steal from you, frame you, do anything, molest you during a traffic stop, whatever. That I'm saying that the courts, by completely ignoring the law that's written on the books that anybody can read for themselves and see what it says, and say, we're not going to pay any attention to that, we're going to apply a different law other than the one that's written down, that is actually a constitutional due process violation. That is the same thing that the Georgia courts were doing in the 1960s when black people came and said, we have rights to this, we have the right to vote, we have to this, and the courts did the same thing. They said, the law that's written on the books, we don't care about. We're enforcing the law that we want to enforce. And so I'm actually arguing that it's 50 years later, a reprise of this same thing, where the courts are doing the exact same thing. The law that's written on the books, we don't care about that. We have our own law we want to impose. And it's interesting reversal, because as an attorney, if you're trying to fight for justice, what happens lots of times is you go in front of the courts with a case, you have somebody who's been wronged, and the court has to tell you, I'm sorry, I know it's unjust, I know the person was wrong, but the law does not provide a remedy for them. And so sorry, but It's not just, but we have to follow the law, and the law says you lose. This is actually the reversal of that, where I'm going into the court and saying, I'm here pleading on behalf of my client, and the law says that we should win. And the court is saying, well, we're so sorry about what the law says, but we're not going to follow the law. And we're going to say, you lose because we say so. I actually had the most recent court opinion that came down, and I'll stop. After years of arguing, presenting evidence, most of it, well, all of it unopposed by the Attorney General's office, that could not even answer our allegations or respond to our evidence. And the court ruled against us just a week ago in a one-sentence order saying the relief you request is denied.
Yeah.
In parentheses, we can't say why. We can't give it any legal justification. We're gonna, and this is like, I could imagine this in Russia, Putin's court doing this, saying, one sentence, you were denied, we can't say why. We're not going to give you a legal justification. We're not going to argue the facts, which were uncontested. We're not going to argue the evidence, which was uncontested. We're not going to give you a legal reason for it. We're just going to say denied because we said so. And so that is the pass that we come to in the expansion of sovereign immunity in Georgia and my attempts to fight it under the Civil RICO statute.
You know, as I sit here and listen to this, Stephen has done just a really fantastic job of detailing all the issues. I'm reminded of the Georgia State Supreme Court ruling a couple of years, 3 years ago, and we're all in Cobb, remember that, where they passed a bond issue without referendum here in Cobb, went to the Georgia State Supreme Court, and if any of you have consulted the Georgia State Constitution, it's there. You must have a referendum. And we had 3 people, Larry and 2 of Madison forum members, arguing that case before the Georgia Supreme Court. And the Georgia Supreme Court ruled that it was perfectly permissible to do that, even though the state constitution is very simply stated. It's also, Father, reminds me of human nature. Our DNA has some flaws in it as human beings. Lewis Carroll wrote a book, and he had to couch it as a children's book in order not to get his head lopped off by the Queen. Everybody remember what that was? Alice in Wonderland? Okay. And then you had Gulliver's Travels by Jonathan Swift. Okay? And again, that was a political commentary written as a fable in order not to be prosecuted. And then in Germany, you had Franz Kafka write The Trial. They come into his house and tell him, you're under arrest. He said, what did I do? He said, don't play games with us. You know what you did. And you better appear at the trial. When they leave, he goes, what trial? What have I done? Where is this trial located? And the book is about him trying to figure out what he's done and where the trial is being held. It's the same kind of thing, and we see it in Washington today. And Stephen has taken such pains in life to go through all of this and to explain it to us. It is just absolutely incredible when it opens the door to Paul O'Malley's citizen access to the grand jury.